Good morning. May it please the Court. My name is Jennifer Hayden. I'm here on behalf of Pamela Carter, the appellee. With me today is co-counsel James Breslauer. The Lynn Housing Authority violated the federal Section 8 regulations by ignoring delineated factors in those regulations, failing to consider mitigating circumstances, and imposing the harshest possible sanction by terminating Ms. Carter's subsidy. Because the hearing officer's decision is void of findings of fact and conclusions of law, it's not known if the hearing officer was A, aware of his available discretion, or B, if he properly exercised it.
But doesn't that discretion only get invoked when the tenant presents evidence that would be subject to the exercise of that discretion? Isn't there some burden of going forward on the part of the tenant?
Justice Spina, there is some burden to present evidence. However,
And that didn't happen here.
My client did present evidence. She presented two witnesses at the hearing. Okay. However, there are mitigating factors that the Housing Authority should consider in circumstances like this, and they have discretion to do so. It's not clear from the...
Did she present evidence with respect to the particular claims that she makes now? I think that was the import of Justice Spina's question.
And that is really at the heart of this case. It is really not clear from the record what was actually presented, because the hearing officer's decision is void of his findings of fact. He reiterates the HUD standard. He talks about how he's going to uphold the decision of the Housing Authority. But a discussion of mitigating factors does not appear. A discussion of how he exercised his discretion or didn't exercise his discretion is void. So it's unclear if discretion was exercised. And it's unclear if evidence was presented. Certainly people were there to participate in the hearing. But
is there an affidavit or some effort to reconstruct the record that was made to the hearing officer?
An affidavit to the hearing officer?
No, it was either an affidavit presented to the hearing officer, or do we have an affidavit in support of the reconstruction of a record that was made to the hearing officer?
Yes, Justice Spina, I believe you're referring to the affidavit of the rental assistant manager, David Moore, who made a post hoc affidavit after litigation had started. And the trial court found and gave weight to that decision as it found was suitable. But that affidavit was not made contemporaneously. It was made months after the fact. And as a note, the affiant wasn't even present at the hearing itself, which is troubling when we're talking about a decision that is supposed to include how this hearing officer comes to the decision that he comes to. Because the hearing officer's decision is void of findings of fact and conclusions of law, it's not known if his discretion was used. The trial court properly concluded that in light of these circumstances, the appellant's actions and omissions rendered the termination incorrect as a matter of law, and as a result, the court reversed that termination. Is the court at all interested in a rendition of the facts?
That is your choice, counsel.
Okay. I think there are a couple of things that are important to point out. Prior to the initiation of the action, Pamela Carter had been a tenant in good standing with a federal Section 8 housing program for over 10 years. A prior landlord brought a summary process action against her, and the two parties mutually agreed to terminate the tenancy, attributing no fault to either.
May I ask you a question with respect to that? And I can't right now find it. I thought they had agreed to settle all claims against each other when they were in front of the housing specialist.
That is my understanding as well. The decision settled all claims up to that point.
Was that not raised as a defense in the subsequent civil action?
In the small claims action, it was not raised. My client did not raise that.
And as I understand it, your client was paying off $20 a month?
Yes, and continues to do so.
Has there been some attempt to attack that decision as that well, do we have the actual settlement, the housing specialist, the document that is executed by both parties when she agreed to quit the premises?
That agreement for judgment does not appear in the record.
And who had the burden of putting that in? So she makes no claim that in fact resolved, because as I understand it, the subsequent actions all stem from the small claims, subsequent small claims by the
solely from the small claims.
Let me just backtrack for 1 second. Do you take the position that the the hearing officer has a duty to conduct an independent inquiry into each of the regulatory factors, whether or not, totally apart from whether or not a plaintiff would even present evidence on those factors?
It's my client's position that the hearing officer is in the best place at the hearing to inquire as to such things.
Even if the tenant doesn't bring it up?
Even if the tenant doesn't bring it up. And in this particular situation, my client, a disabled person, at an appearing pro se with witnesses, presented what she believed was what would have been considered. However, the regulations speak to other things that the housing authority's hearing officer would have been in the best position to look at. Mitigating circumstances, such as the seriousness of the case, the culpability of other family members, the effect this termination would have had on other family members, the relationship between the disability and the action, all of these things. And there's nothing in the hearing officer's decision that speaks to whether those things were considered.
Now, the Wojcik case and the Carter case came out the same day.
The same day.
Do you read the Wojcik case to say that the independent, or that the hearing officer has this independent duty that you've just described?
Absolutely.
I had a little bit of difficulty trying to figure out whether the tenant had presented this evidence or whether the hearing officer conducted, pried it out of it, was pulling teeth at the hearing. And I'm not so sure it's clear. Is there something in that opinion that really makes it clear, that would ice it for me, that the hearing officer conducted an independent inquiry? That
is one of the quintessential questions before this court, is that it's not clear from that record. And that the trial court, therefore...
It's not clear from the record or not clear from the opinion?
It's not clear from the hearing officer's opinion, excuse me.
In Wojcik.
In Wojcik.
In Wojcik.
I'm sorry, I was confused. If you could rephrase the question.
Yeah. Is it clear from the Wojcik case that the hearing officer has an independent duty to essentially pry information from witnesses conformably with the factors that are in the regulation?
I believe what Wojcik holds is that the hearing officer has to delineate those factors as having been considered and must give that as part of his decision.
But the decision itself doesn't specifically say that the hearing officer must do that independent of any presentation that was made by the parties.
I don't believe so.
Okay.
Was your client represented in the small claims action brought by the landlord?
No, she was not, Justice Marshall. Both the applicable federal Section 8 regulations and a long line of case law, including the United States versus XREL, Accardia, concerning the appropriate exercise of discretion, make clear that where an agency is vested with discretion and provided a clear set of factors to consider, the agency must exercise that discretion and consider those circumstances. The trial court concluded that the housing authority hadn't done so. It noted that the housing authority's decision was entirely void of any mention of the consideration of factors, and the court further concluded that under the actual circumstances presented, imposing the harshest possible sanction of removing this voucher from Ms. Carter would be clear error and an abuse of discretion. It was correct in all of those points. The regulations address permissive authority to terminate assistance of a Section 8 participant, in this case because of the breach of the housing quality standard. Those regulations can be found at page 70 of my opponent's brief. The regulations detail in specific those things that I delineated a few moments ago: the seriousness of the case, the extent of participation, culpability, mitigating circumstances, and the effects of termination.
Ms. Hayden, forgive me for interrupting you. I want to return to something here. We've got a very long-serving housing court judge here, and he, I think, appropriately considered his standard as an abuse of discretion by the housing authority. But I'm looking at his reasons for why he concluded there was an abuse of discretion, particularly 3 and 4, and maybe Mr. Plamason can anticipate this, where he states as what appears to be a fact that the landlord overstated the extent of his waste damages in the small claims case, and that there was no evidence and no claim that your client, the tenant, had committed active waste or malicious destruction to the property. Where is that evidence coming from that appears to form the basis of Judge Kerman's decision?
And I believe that that would come from the actual small claims decision itself, found at page 3 of the record appendix.
So was the judge sitting in review of the small claims decision?
No. No. Wasn't reviewing it. Was reviewing it as a factor that could have been considered by the Housing Authority. But it's not clear if they considered that or not, again. The regulations make clear that it is never required for a housing authority to terminate in circumstances such as are presented here today. And that instead, to terminate is a discretionary decision. 24 CFR 982.555 instructs public housing authorities on informal hearings for participants. The regulation reads, a public housing authority must give a participant an opportunity for an informal hearing to consider whether the public housing authority's decision relating to individual circumstances of a participant family are in accordance with the law, HUD regulations, and the public housing authority policies. Read together with 24 CFR 982.552, which instructs public housing authorities on, among other things, the consideration of the circumstances, or its authority, to terminate assistance under the regulations. Specifically at 982.555 sub 2 sub 1, entitled Consideration of the Circumstances. A public housing authority may consider all relevant circumstances, such as the ones I talked about earlier. Read together, my client asks this: how can there be a mandatory hearing to consider individual circumstances, that's 982.555, if there's no obligation to consider those circumstances, 982.552?
Do we know who caused all the damage that was done to this apartment?
What we know is that there is a small claims judgment against my client.
There's nothing anywhere in her words where she said some third party came in and destroyed this. I mean, we don't know if there was a break-in. We don't know if one of her kids did it. We don't know if she did it. We don't know if there was an abuser in the family. We don't know anything about the circumstances. Isn't it her obligation to come forward with some evidence as to how this happened? Isn't she in the best position to make that claim?
She may well be in the best position, but it's not clear from the record if she did say that. If she did say that, it's not referenced in the decision of the hearing officer. But
no, but that is why I asked you about Judge Kerman's finding. That is to say, maybe it is sufficient that there was no evidence and no claim that she committed active waste or malicious destruction to the property. And then I look at the appeals court decision that said she denied that she had caused any damage beyond ordinary wear and tear. Do we know exactly when the photographs were taken? Were they taken the day she quit the apartment?
I don't know when the photographs were taken. It's not clear to me.
Well, it's not. The question is not as clear. Is it in the record when the photographs were taken?
I do not believe so. The small claims decision doesn't indicate that. And that's where those photographs would have been presented.
Well, what was the housing court judge basing his decision on? I mean, was there a record that was made there that we can look to where he said that the landlord overstated the amount of damages? What was the judge basing his decision on?
The judge was basing his decision on in determining whether the housing authority had abused its discretion. And he found that under the circumstances, with no record or a record void of things to review, the decision was an abuse of discretion.
But where did he come up with the statement that the, as the Chief Justice was asking, that the landlord had overstated his claim for damages? How does the housing court judge know that? Somebody must have told him something, or is he guessing?
I'm sorry, I understand the question now. The original small claims complaint states damages in excess of $1,400, which is the judgment that my client received against her. There were damages that exceeded the small claims limits, over $2,000. Once the case was heard by the magistrate, they were reduced to $1,400.
Okay.
I think that
So he's basing it on the claim that was made in small claims court, a claim for X amount of damages, and the fact that the clerk magistrate in the claim session of the housing court came back with a judgment of $1,440.
and no reference to malicious destruction of property or active waste. Yes. See, I'm running out of time.
Oh, you have run out of time. Thank you, Ms. Hayden.
Okay. Thank you very much.
Is it Plymason?
Primason, Your Honor. Thank
Plymason.
you. Good morning, Your Honors. My name is Webb Primason. I appear today on behalf of the appellant, Lynn Housing Authority. In addition to seeking a final resolution from this court with respect to the Housing Authority's case against Ms. Carter, the Housing Authority has a sincere desire and interest to have this court give it some clarification with respect to two subject areas that are raised by this court. The first of those subject areas is what are the obligations of the Housing Authority in terms of the content of its communications with a participant whom it has decided to terminate.
You mean in terms of a written decision?
Well, there are two documents, and one that I have in mind. The first is prior to the tenant exercising a right to seek a hearing, there's a requirement that there be a notification because a decision maker, in this case a program manager, made the decision to terminate the tenant's participation. And then because a hearing was requested, there's a second communication, and that is from the hearing officer in the form of a written decision. And the decision of the housing court in this case and the decision of the appeals court in this case both focus to some extent on the contents of those communications, and the Housing Authority is left in a position where we're really not sure what it is that is supposed to be contained in those documents.
Mr. Plymason, I'm sure we will provide you with excellent guidance, or at least I hope we can.
The Housing Authority would appreciate that, Your Honor, because there's certainly a confusion in those decisions with respect to what is required. And my brief it contains fully what our position is with respect to what is and what is not required.
May I ask you this again, and if it's not in the record, or if you can't tell me, that's fine. But is the record with which the housing court judge took issue typical, atypical? I mean, sort of looking at it, you ask us for clarification, but if it turns out that there's typically been a recitation of the factors and so on and so forth, and this is an unusual case in that respect, that's one thing, as opposed to this is what the Housing Authority has regularly done, and so the decision of the housing court judge that there was something that reflected an abuse of discretion is seriously problematic. Can you help me?
I honestly can't, Your Honor. I don't know how to respond to the question whether it's usually done. There aren't that many termination cases upon which to say to you, this is the usual habit, this is
Okay.
Are there many cases?
No.
Because they're usually done by agreement, correct?
I'm sorry?
They often are worked out.
There are a myriad of resolutions that occur at various stages following an accusation or the Housing Authority receiving information of a potential violation of the program. There are private conferences, there are meetings, there are efforts to work things out. I couldn't provide you with statistics, but certainly not every case goes to court or results in a decision for termination.
I think we can take judicial notice that in many of these cases, one or both parties are self-represented, I think in about 80% of the cases, and a similar number are resolved informally, usually with an agreement, which led me to this. As I understood the recitation of the agreement between the landlord and the tenant at the time of termination, which I haven't looked at itself, I was surprised that there was a subsequent small claims case.
I misunderstood your question. If you were referring to whether it was usual for there to be a resolution between landlord and tenant in the eviction case, because the Housing Authority was not a participant in that case. I misunderstood. I do have a lot of experience with respect to that, and yes, that is very common for landlords and tenants to resolve disputes at the housing court level by agreement with the help of the court
All of their
specialist.
disputes, including any damages, or, in other words, if there's serious damage, somebody says, you're entitled to your security deposit, but I'm not going to pay you your full security deposit because there's $700 worth of damage.
And sometimes the landlords waive those claims because they would like to have
They want the property
They want
back.
the possession. I mean, there are a myriad of reasons why a landlord in that position might want to waive some of his or her rights. Everything is usual in the housing court with respect to landlord and tenants.
Is there anywhere in this record a challenge to the commencement of a small claims action in the wake of that?
No, there's not. And my assumption, Your Honor, is that the intent and, in fact, the interpretation of the housing court agreement for judgment in the eviction case was that the landlord waived any claims he might have for damages which existed or which he had, or causes of action which he had at that point in time.
There would be nothing in his discussions. Did this go to a housing specialist?
When you say this, you're referring to
The eviction case.
I wasn't a participant.
Okay, but I thought my
I
memory
believe the
is-
record indicates that there was a housing specialist who signed on, yes.
Okay.
And that's also very common, that the claims are waived as of that moment. But I doubt sincerely that the landlord was waiving a claim that, because one of the terms of that agreement was that the tenant would move out, I think, 60 or 90 days hence. So there was a date of September.
Which is why I asked whether there was any evidence as to what the date of the photographs was.
I believe that there was evidence at the small claim hearing. I wasn't there. But there is no evidence in this record with respect to that specific question.
So the
But
theory
it seems
was
clear that the landlord's position was,
the damage was done afterwards.
certainly,
Okay.
just from the fact that he brought the small claim, I think it's reasonable to infer that the landlord's position, which was sustained by the clerk magistrate, was the damage was done by this family subsequent to the time that I entered into the agreement, probably. And here are the photographs that I have to show you. I think one can assume that, but as to the specific dates, I don't have them.
Now, I take the tenant was a tenant of this Section 8 landlord for a couple of years before the damage was done.
Yes.
And the record is silent, but I take it that there were no complaints by the landlord to the housing authority about this particular tenant up until the time that this significant damage was done.
I don't know.
After the eviction case, the tenant then was able to get another Section 8 lease with a different landlord.
Yes.
And there have been no complaints by this second landlord about this tenant.
I don't know.
Or at least there's none in the record.
Certainly are not. There's nothing in the record. That's
Does whatever the hearing officer's obligations are, whether he or she just responds to evidence that the tenant presents or has some independent obligation to go down the factors in the regulations, it seems awfully odd in this case that the tenant's Section 8 rights were being terminated while she had a Section 8 lease in effect without any apparent complaint from the new landlord.
Well, the complaint or the violation of the program regulations, which the housing authority enforces, don't have to be brought or instigated by the existing landlord. In fact, it's common that they're not.
But wouldn't that be one of the factors, at least if the hearing officer were conducting an independent investigation, isn't that one of the factors that would come into play in a decision to evict? That, there was damage at one apartment, we apparently have no explanation why. She's now in a new apartment and there are no complaints about her.
I don't think it's a factor with respect to the housing authority's consideration that, she trashed one apartment, but she hasn't trashed the next one yet.
But the problem here, Mr. Plimmerson, is that I think that what both Judge Kerman and the dissent in the appeals court were saying is she did, in the sense that she said it wasn't me, not who did do it. She might have been in that, but it wasn't me. It's my Section 8 rights that are being terminated, and we don't, as it were, have an explanation from the housing hearing officer on the termination about the relevant circumstances. I don't have to recite it back here again, and that's what seems to be the nub of it. So when you say what the housing authority was doing was terminating a Section 8 tenant because she trashed one landlord's apartment, I think that's not clearly established here. If that were the case, then I assume we wouldn't be here.
Well, the evidence of that violation by the household is the small claims judgment.
Then I take it that you take issue with the statement of Judge Kerman that there was no evidence and no claim that the tenant, not the tenant's family, committed waste or malicious destruction to the property.
I do differ with that. I have no idea where that came from. And I'm not sure what the, frankly, I'm not sure what active waste means or malicious destruction. That's not, the tenant's obligation under the regulations is not to refrain from committing malicious destruction. It's to refrain from committing damage, whether it's caused maliciously or negligently, which the tenant does not then take responsibility for.
Can I go back to the two questions that you say you need to know the answers to, the requirements of the content of the notice of the termination to the tenant and the requirements of the content of the hearing officer's decision?
That was one area, Your Honor, of the two.
Okay. But let me ask you, if we were to agree with the tenant in this case that the hearing officer has an independent duty to make inquiry into all of the factors that are in the regulation, what kind of a problem is that going to create for the Public Housing Authority, if any?
Difficult for me to speculate without having thought about it, quite frankly, Your Honor. But
has any other court interpreted these regulations this way? Do you know?
Not that I'm aware of. In fact, the interpretation, as I understand it, is quite the opposite. That from in the Wojcik case, quite frankly, I argued to appeals court that the hearing officer was an independent hearing officer, not part of the housing authority. And the appeals court reversed me with respect to that position, and the dissent in this case pointed that out, that because of the position that the housing authority took in Wojcik, we were unable to make certain other arguments in this case. So now that Wojcik has taught the housing authority certainly that the
Well, Judge Duffy is correct. I mean, she said Wojcik just told you to do something and you didn't do it.
Well, I'm addressing a slightly different point. Wojcik told us that the hearing officer is part of the housing authority, and that decision is that of the housing authority as opposed to an independent kind of a person. And in Wojcik, the elements had to do with the fact that there was the housing authority indicated, pursuant to the regulations, that it was choosing in that case not to follow the decision of the hearing officer because the housing authority believed that the hearing officer had exceeded his authority. That's not present, certainly, in this case.
In the Wojcik case, did the hearing officer simply make a decision and weigh the evidence that was presented, or did the hearing officer in Wojcik go out and find facts, drum up facts? I don't mean, fabricate.
I'm pretty certain, Your Honor, that in Wojcik the hearing officer responded to evidence that was presented to him as opposed to
and played sort of a passive role in that sense.
Yes, played more of a judicial role, so to speak, in the sense of responding to evidence presented at the hearing as opposed to conducting an independent investigation.
Do you have an objection to a hearing officer putting in writing what they base their decision on?
I do not. But the question is whether or not it's required under the regulations, and secondly, if a hearing officer does not do that, is the appropriate remedy summary judgment for the tenant, or, as is suggested in the dissent of the appeals court justice in this case, a remand to have that record corrected?
Well, shouldn't the hearing officer summarize what the evidence was that was presented?
In this case, I believe he did. The evidence was the evidence relative to the offense, that is, the behavior that is prohibited by the regulations, was the small claims judgment. The evidence offered, as I understand it, by the tenant, and I only understand it from the record. I have no independent knowledge of it, any different. My knowledge of it is no different than yours. My understanding is that the defense that that the evidence that she presented was from neighbors of hers who said she's a very good housekeeper. I mean, I don't mean to minimize that, but that she keeps her
Mr.
apartment
Clemson,
nice and neat and clean, and I assume the inference she was
Well,
seeking to
here-
have drawn was that she would not do something.
I take it, though, in the Wojcik case, if I understand what the court was saying, is, and this is where it sort of gets to its final conclusion, about what the hearing officer should do, the housing hearing officer, is to consider individual and mitigating circumstances as well as bare facts relating to the event. I take it in the context of this case, that would be, let's take as definitive that that there was damage to the property after the resolution in the housing court, but before she quit the property.
Or on the way out.
Or on the way out. But as I say, before she quit it, before she handed it back over, while she still had control over it.
Yes.
That he brought a small claims action, and those facts were established. But what the hearing officer should have done, according to Wojcik, was to see for how long she'd been a tenant, what her prior history was, what her current circumstances with the current landlord.
Well, my understanding of the dissent in this case was that not that the hearing officer didn't do it, but that his written decision didn't reflect whether he did or did not do it.
No, I'm looking to the Wojcik decision,
Okay.
saying that's what, and that seems to me, when you're saying what are we supposed to do, it's not only tell me the basis, that's just a silence question, but also I'm telling you, you've got to take into account all kinds of individual and mitigating circumstances over and above the bare facts relating to the event.
Except that the appeals court indicated in this case, or in Wojcik, that the regulations do not say we have to take those into account. They say that the housing authority may consider those circumstances, such as, and then enumerates some examples. Before my time is up, which I gather it is, I just wanted to respond, Justice Spina, to the second area about which we're hoping to have some clarification, and that is certainly going to come out in the other cases that you're hearing this morning, as I can tell from the arguments, and that is what is the appropriate role of the trial court when making a review of a decision,
Right.
and the whole issue of whether that review, as Justice Cordy indicated, is ought to be on an abuse of discretion standard. And clearly our position is that we do not want to have and do not believe that it's lawful or that it's the appropriate role of the court to be substituting its judgment with respect to the sanction for the judgment of the housing authority in the absence of an abuse of discretion by the housing authority. Thank you very much.
Thank you, Mr. Clemson. We'll take a short break.
All right.